I speak to you here more in the nature of in the character of a corporate lawyer who's been practicing in this specific field now for just 40 years. Though my relationship with the industry or the profession goes back longer, because I actually was a paralegal and or intern in a law firm on a full day basis, and I did my law in the evening classes. And so very early days, I was very young. I was just about 19 and a half when I got involved with the profession. So my whole life has been in the field, so to say. And what I'm going to sort of talk about today is probably in three main baskets. Let's put it like that. One is to give a little context to the words used in the topic, and it talks about skilling legal talent, and it talks about emerging areas. So in terms of talking a little bit about the context of why we are even talking about this. The second is a conversation with you on education versus skills. And the third is a little bit more about role of a lawyer. We had glimpses of all of these three in the remarks made by Justice Kumar, and also very eloquently by my friend Rupinder Suri. So I'm going to touch upon these three. So first of all, let's just go back to say 40 years back when I started this journey in the profession. What is it that we practiced at that time, how we practiced it, and why was that market at that point in time the way it was? So what did we practice? First of all, there was hardly any specialization. Everybody did everything. In the morning you went to the court on a matrimonial matter. In the afternoon you wrote a collaboration agreement. How we practiced? Laid back. Just imagine that there was no fax machines. Forget about email. The fastest means of communication was telex, which very few law firms had or lawyers had. There were no courier services. So if you wrote a letter to somebody, a client in London, it took a week to get there. The fellow sat on it for a week, he wrote back it took 1 week to come back. So you completed one round of communication in 3 weeks. The economy was a very closed economy. Just think of it that government had full control, monopoly over things like telecom, electricity, oil and gas, major industries, postal services, transportation. So think of anything, and the government had control. Now what that meant was that lawyers really had no significant role to play in the economic field or in the field of industry. Very little, hardly any. And when I will just now give you a contradistinction of what we are doing today, you would be surprised. I mean, I'll just talk of a few practices. Let's talk of banking and finance. Even about 25 years ago, 26 years ago, before 1991 and the liberalization, the banking practice consisted literally of 3 documents. We used to have long-term lending, printed document, 85 pages, which was a common document shared by IDBI, IFCI, and ICICI for long-term lending. So you wanted a project loan, which was long-term, payable over 10 years or 7 years or whatever, you signed on the dotted line. Working capital, was two standard documents. It was called the inter se pari passu agreement between the banks and the borrower, and a deed of hypothecation. And this was prescribed by the Indian Banks Association. You sign it on the dotted line. So that was the banking practice. Mergers and acquisitions. We had the 1969 Monopolies and Restricted Trade Practices Act, which simply said that if your group assets are 20 crores or more, you cannot acquire any new business without going through the MRTP process. 20 crores. I did my first M&A transaction with a value of 1.08 crores 12 years after I had gotten into practice. M&A didn't exist. Private equity did not exist. Capital markets and securities laws did not exist. There was no takeover court, there was no insider dealing, there were hardly any listings on the stock exchange. There was no infrastructure practice because everything, roads, ports, airports, airlines, telecom, municipal infrastructure, oil and gas, you name everything, it was all monopolized. So private sector had no role, and government didn't need lawyers. I mean, they wrote the laws, they don't need lawyers. Regulatory practice didn't exist because there was no regulation, it was not needed. Dispute resolution obviously is the end result of all other economic and legal activity that you have. So disputes were very, very few. Personal disputes, property disputes, corporate disputes were very limited because corporates were present in very, very few areas. Now you see what I'm talking about, because what my colleagues do today, I never did it in my early days. I didn't do that for 20 years of my first years of practice. So everything is changed. Now, things happened globally. We have globalization, we had the WTO come in, we had competition which has increased, the country opened up, and then you therefore had private sector participation, which meant that you now have more laws. You have the Electricity Act, you have the IT Act, then came the Competition Act, then came all the regulators, because all of these industries, if private sector people come in, they have to be regulated in some form. So you had a whole change of the scene. Now, we heard earlier this morning that industry actually, the recipients of our service are our clients, that's the industry. And services are not sold, services are bought. You have to have people, you have to have an audience who will buy your services, and they will buy what they want. They are not going to buy what you are selling. So for the profession then to react to it and say, okay, I now got to change myself and I got to now prepare myself for what my clients need. I'll give you another example. In early days, most corporate lawyers did a lot of work which is now done in-house by larger companies. Clients would come out and say, can you please write up minutes of our board meetings? Can you do some corporate compliance work? Now, all of that work has basically disappeared because all large companies today have in-house departments which will do that. And why would they come out? They come out to get things that they can't do in-house. And that's where is really the convergence of the subject that we are talking today, which is skilling and emerging areas. So industry needs people who are experts, who are going to provide those services that cannot be provided in-house. And that's what brings us to the entire debate, entire idea of specialization. Now, and I will give you just a few examples and some of the experiences that we had. And it will lead me into the second basket that I want to talk about, in education versus skills. Just one example, 1994, India signed WTO, and suddenly we had deep interest in the intellectual property space. Now, suddenly intellectual property became a very important subject, and of course, sometimes very controversial subject, things like pharmaceutical patents and so on and so forth. And suddenly we are now open to the globe, and we have same standards apply across the world on intellectual property laws. Now, we've had intellectual property legislation since 1850 or 1860, if I recall, the first laws were paid. But we did not have, frankly, an intellectual property bar in this country. We did not have really truly intellectual property lawyers, and I've been involved with intellectual property since 1975. And I'll give you just one example, that when we would do a patent application, typically there was nobody in this country who could write complete specifications for a patent application. And we would get this patent application coming in from a foreign associate or a foreign client because they were equipped to write this. All we did was we filled in our Form 1, slapped it on top, signed it, and we filed it in the patent office. When the first examination report came, we just covered it again with the letter, sent it back to the client. They prepared the reply. It came back to us. We put it on our letterhead and we filed it. And the patent office never held any hearings, literally none, for prosecution of a patent application. And now comes this entire new world where you suddenly have Indian filers, the filings go up. So we, in our intellectual property practice, started to wonder in 96, 97, about 20-year back time frame, to say, well, we can't be a post office. If we have to add value to our clients and we have to practice the law way law is practiced elsewhere in the world, we need to have technically qualified people who are not only technically qualified, but they're also lawyers. And lo and behold, what do we find? It's not a surprise that most lawyers come from humanities and liberal arts backgrounds. So in a way, what you're trying to do in terms of the technology and law thing is something that we encountered 20 years back. So our solution was what? We went out to technology institutes, including places like the IIT. And we started selling the idea to those young technology students that there is a profession called a patent attorney's profession. So we started bringing in these people. 1997, if I recall, was the first batch. And what we encouraged them to do was work with us during the day and go and do their law classes in the night. And from year 2000 on, we started getting a crop of people who had technological backgrounds. Right now in our patents group, I think the minimum we have is at least a master's in engineering or the relevant area of technology, along with law. And I can see one of my colleagues sitting here. He's a PhD, Dr. Shishindra Pandey, he's sitting right there. Maybe you can raise your hand. He's one of those people who's come through that process of actually being a PhD and then coming and becoming a lawyer. So he's a patent attorney. So we face these challenges as provider of services, that we could not get people who really could fill the needs of the industry or what was required. But that's changing. We are seeing that. Now, that leads me into the next topic of legal education versus skills. And to be honest, and you can talk, about that to any partner in any corporate law firm. And I'm speaking again, I said, from a corporate law firm background or context. The students who come in, the fresh, young, greenhorn lawyers who come in and they join us, frankly, have very little relevant skill that's required to practice as a corporate lawyer. Literally almost zero. Sometimes they have to unlearn things and learn the way we practice law. Now, why do I say that? Now, let me sort of, from my personal experience, there are things which are different when you're practicing in a law firm versus when you're practicing on your own, and particularly when you are a litigating lawyer. Quite distinct worlds. Now, because of specialization, it will be a misnomer for someone to say, I'm a specialist in 10 fields. That will be an oxymoron. It won't be true. So if people are specialists, and I'm talking of specialization can really be in this context of two kinds. You can have practice horizontals. You can have a corporate practice. You can have banking and finance, which are all I would say they are practice horizontals. You can have M&A and PE. You can have regulatory infrastructure projects. And then you have the verticals. And those are industry verticals, sectors. You have the pharma sector, you can have media, entertainment and sports, you can have hardcore manufacturing, you have knowledge-based industries. So just imagine that you have these horizontals and then you have these verticals. And you suddenly see, okay, now some specific industries do require a lot of industry experience. For example, information technology. So you need to have people who are very familiar with what are the nuances of that industry. Now, when you have this kind of a thing, that is what leads to size. We heard this morning, Rupinder spoke about law firms overseas having thousands of lawyers. That's indeed. The largest international firm has 4,500 lawyers. They have a top line of $3 billion. They will have 500 lawyers who do competition or antitrust work. They will have X number of lawyers who do only power projects. You will have Y number of lawyers who only do non-conventional power, non-conventional energy. They do solar and they do wind. They don't do anything else. So there is super specialization. Why I'm saying all this is that the way law firms are developing, and we today heard that we should have larger law firms, now that brings into focus skills that are not even thought of in a law school. So what are those skills? People's skills. How do you work together as teams? They're not even thought of in law school. Negotiation skills. Communication skills. Presentation skills. I mean, I would say literally a lot of these are beyond the technical legal skills, because for us as law firms, we believe, and the clients expect you, and you will be hearing from the other co-panelists as to what the in-house people expect their law firms to provide. I mean, at certain level, I mean, a technical legal skill is a given. You have to have it. But beyond that, you need more skills. And a lot of those skills are soft skills, and I'm afraid that law professors and law schools neither have the capacity nor the competence to actually teach those skills, and same applies even to law firms. And I think that's a big gaping hole in our system. So whether it is teamwork, whether it is relationships, because when you and I mean, I call it a very large piece, and maybe you should pick it up and see if you incorporate it in your system. is not only just about emotional intelligence, EI, you keep on hearing about that, or EQ. It is actually almost emotional literacy. Learning about how to work with people, learning about relationships, learning about dealing with your peers, with your juniors, with your seniors, when you are, or with external clients, how to sit in a meeting, how to say what and when, how do you communicate properly and clearly. Now, these are skills which are required in today's practice. The fact that you know your law very well and you can recite Supreme Court judgments, yes, it's important and relevant, but it's just not the only thing you need. And I'll give an example. I mean, I was asked 2 years back by young people within my firm to say, what does it take me to succeed? And my answer was, well, succeed within the law firm and succeed externally with your clients. I think, frankly, ability to build and maintain relationships is the most important thing. The ability to influence others and cooperate with others, collaborate with others, and do teamwork is actually the most important skill. Because interestingly, and that's what I realized as I went along in my own on building my firm and professional career, because I was for 19 years in a traditional type of law firm, and then I started on my own as a solo in one room in a hotel in Delhi. And from there to build, and as I learned something very interesting along the way. And the interesting thing is that actually as you rise up, and I'm not talking about a senior counsel, because as they rise up, the more independent they are, the better they are off. But for us as corporate lawyers and running a corporate firm and an institution, if you are trying to create, the very fascinating thing I found was that actually as you go up, you are more and more dependent on others. When I was an associate in a law firm, my world was 4 feet by 3 feet, my table, what my senior gave me to do, I did that well. And I gave it back to him. And that was super. But as I had people who are now working with me or under me or by my side, my success was dependent on what they did. It was dependent on that more and more. How I could influence a client outside so that he would give me work, I was dependent on that person. So the success is actually dependent on those who work with you, are your peers or your seniors or your juniors. Your success depends on those people. And what do we typically learn in law school actually is still the old traditional mode of contentious practice, where you say, well, I win and you lose. I see that all the time. So these are times when it's not win-lose. A lot of the time you will not succeed unless you're going at least with the formula of win-win, or at least consensus building, because that's what all we lawyers do as corporate lawyers. We are trying to do negotiations, consensus building, whether it is on transactions or whether it is within the firm. We work with large teams, and you cannot just work as in silos and by yourself. It comes to things like, I give you an example. Specializing means really, as I said, that people work in a very specialized area, focused area. And I'll give you a simple example. We have living examples of that in our own practice. Say a oil company or an oil and gas company, since we are talking about a university engaged in hydrocarbons, is coming up with initial public offering. Now you're going to write a prospectus. Now a capital markets person with experience on capital markets is the lead. But here it is, you got to write risk factors. Now if you got an oil field or a gas field, it's onshore, offshore. Now the way a hydrocarbon specialist will write those risk factors and give his inputs. A capital markets guy can never do it. It's impossible. Now, so you have people working together as teams. It's very, very important, and that's the reason why I'm emphasizing on that, that it's important that these skills be taught to young lawyers who are coming out into the mainstream, because that's what they're going to face. So really, I put it very broadly here, and I said life skills are even more important if they have to be useful to a law firm and if they go in-house, because in in-house situation, again, you're dealing with a large number of people around you. Now, I moved sort of, I mean, I would say simply I had a little thing here which said here, soft skills are becoming the hard needs. This is what I wrote this morning as I was trying to say what I'm going to say. So soft skills are the hard needs, and that's what I think the skilling is very, very important there. Now, I'll just come to the last point, and I think Justice Kumar and Rupinder, they both spoke very eloquently about that, and that really is in terms of role of a lawyer. And I'm not sort of, you know, and I'm very mindful that there is a lot of cynicism about lawyers. We actually have a situation where, you know, the lawyers don't really have the kind of respect that they had at one point in time. I'd sort of like to repeat what Justice Kumar said, and he didn't use the words, but I'm using the word that we've ceased to be healers. We cease to be leaders. We cease to be the people who stand up for, in a way, for rule of law. And actually this morning I came in, and this session we were chatting with someone, and you know, we were having a little group chat here, and I was asked this question that, you know, young lawyers come up and say, well, you know, should I go into litigation, and do I go into corporate where I will make more money? And I just suddenly stuck to me, and it's been something which stayed with me actually over the last few years as I have seen my own life and looking backwards and saying, what happened to our noble profession? Have we lost our way somewhere? And are the schools doing enough to say what is the public and the community role of a lawyer? So we're missing something somewhere. And talking of, you know, ethics, what is ethical, what we should do, what we should not do. It was quite stunning actually this morning as I was coming in from Gurgaon, coming here, and I saw this middle on the editorial page in the Indian Express, and this person, obviously he goes by the classic name of John Doe, because he's the person who leaked the Panama Papers. And just see what this person has to say. He's the guy who's the source of the Panama Papers. And I was stunned. I said, how amazing, you know, that I'm going there today for a session and I get to read this one paragraph, and I would like to read it to you. But most of all, the legal profession has failed. Democratic governance depends upon responsible individuals throughout the entire system who understand and uphold the law, not who understand it and exploit it. On average, lawyers have become so deeply corrupt that it's imperative for major changes in the profession to take place, far beyond the meek proposals already on the table. To start, the term legal ethics, upon which codes of conduct and licenses are nominally based, has become an oxymoron. Mossack Fonseca did not work in a vacuum. Despite repeated fines and documented regulatory violations, it found allies and clients at major law firms in virtually every nation. Just think of it. That's what the world thinks of us. And what you as educators and their students here, what we can do to change that perception. I will just close at that. Thank you.
Thank you, Mr. Sagar. I'll reserve my little reflections after the other panelists concludes. And let me request Mr. Prem Sharma to take over.
Thank you, sir. Good morning, dear friends, senior faculty members, and respected panelists. The topic has been really very well covered and beautifully captured in the previous session and this session as well. And as I was hearing and listening to it, I just realized Mr. Sagar started, and I'm sure other members also, practice when I was not even born. So, with my not so deep experience, I would like to share a few pointers with each one of you on the topic which was shared to me and told to me. The topic itself intrigued me, and I'm sure it intrigued every one of us. In my experience, I had worked both in-house and also practiced in a law firm. And there I realized that we do dual role, not just serve the industry, we also serve the society, more like a medical practitioner. And it becomes all the more critical and important for us to first know what exactly we want and how to build the gap between the laws and what our advice is to our prospective clients. And the whole thing of morality, ethical behavior, the advices, all that will come into play then. Now, in today's topic, we've talked about mostly on the skill set requirements. It's important for the education side or the academics, people who are running the institution, colleges, universities, to have a curriculum which is meeting the requirement, the present day requirement of the industry. And it goes without saying that it should be within the realm of the existing laws and all that, because there have been instances where we've talked about few audit firms and tax firms advising on efficient structures. Now, how relevant would that be? Whether that's within the spirit of the law or not, that's a big debate. In banking sector, if I talk about the skilling and the requirement of the fresh generation of lawyers which are coming in, few points Mr. Sagar has already talked about, which mentioned about the softer skills. And I feel the curriculum at the university level should have a dedicated session or subject matter which should build upon that. In the service sector, it's the need of the hour. We have to meet people, we have to negotiate with them, even though there is loads of information and knowledge about all the relevant laws. I still feel at times we are lacking in the softer skills aspect. So that's a very important takeaway for each one of us, and especially the new lawyers which are coming and joining the industry on both the sides. In addition to that, I've recently also invited. I was invited in the university in Dehradun, so I had a chance to briefly see I had a discussion with the students and also these faculty members, and I realized how fantastic is the curriculum is, which was never there when I studied law. So, but in spite of having curriculum and the overarching subjects and topics, there's still a gap. So that gap needs to be filled in. Probably more industry exposure, internships, and keeping track of these key points which should serve the purpose. There are other developments which are happening in the banking sector. I mean, it's going through a lot of changes these days. A lot of discussions are happening, a lot of regulations are coming in. So somebody who's interested in banking and finance industry, he should keep a tap of that. He should read about that. He should discuss with his teachers, the industry experts during the internship or otherwise. I'm sure everybody would know about the new banks which are coming in, the universal banks, the conventional type banks, the licenses which are given to the payments bank, the custodian banks which are coming in. So all that is changing and churning the whole environment, and it's very critical for the newcomers to read, understand the larger ecosystem and prepare themselves. And I mean, on that I would like to conclude and share my few points. Thank you.
Thank you so much. Of course, we started a little late, but I suppose we haven't lost in the process. Quickly to catch up and to link it to the next theme, we take it as an important insight that unlike a private litigating lawyer who stands on one's own legs and tries to respond to the needs of the institution, the court and the client, and regardless of whatever the Bar Council of India rules may say about the duty to the client, duty to the other side, duty to the institution, duty to the community, long list of duties notwithstanding, every individual litigating lawyer grows in their own way, depending upon the area where one grows and gets into. And I've seen that that is an insufficient pool of expertise on which we can draw on to be able to extend it to other areas of developing practice. Mr. Sagar is very right there in talking about and emphasizing the emotional literacy aspect of it. And of course, there's a lot of meaning and potential which one can expand and see how we build the skills imparting in a variety of ways. Because connected to it is the question of how to link professional ethics in different perspective. Professional ethics in a very narrow perspective is about duty to a client and be fair to the court. But when talking about professional ethics in the emerging scenario, two schools of professional ethics in the world all over seem to suggest to us to take fresh insights into it. The original old traditional school is that whatever your client needs you to do, you must do, regardless of the destructive efforts it has on the system or the community or the other party. But the other emerging trend is that your larger social, moral, communitarian responsibilities, which must inform each and every aspect of the profession. So this emerging trend, of course, will have greater applicability to the larger areas of the legal education and emerging areas of practice. So for instance, let me share with you one of my private concerns. I've been setting the question papers for the advocate and record examination for quite some time now, giving lectures and correcting these answer sheets. And for the past couple of years, I'm setting question papers on professional ethics. And when you engage in lectures with the advocates who want to practice in Supreme Court, and the level of intake at the lectures stage, and you look at the quality of performance in the examination, I have lots of problems. I have lots of concerns. And one would like to probably say that that many of them who want to aspire to practice in Supreme Court are probably to a large extent unfit to, even because fundamentals about what links the role of the profession is not even comprehended, then we have serious problems somewhere in the university education system. So when there is only a state-controlled economy, there is less law. But when the economy becomes open, in an open society, there is need for a great amount of law. Because every activity in a free and open society deserves regulation. And regulation, the absence of regulation, we cannot probably expect altruistic individuals to self-control and regulate themselves and be able to produce the best results for every human being. Concerns of today, I think one of the major problems in a free and open society, which law schools must take note of, is the need and ability to promote and generate wealth and value of a wide range, consistent with equality and equal, opportunity concerns. So in an open society, this can be dealt with, and only through a very well thought out legal pattern. We talk of well thought out legal pattern, then we require all that kind of inputs which are required to play a great role in that. I am thankful to Mr. Sagar for flagging some of the major concerns and how you really peep into these issues. If universities have not even looked into them, as I said, not only here in world all over, the question of instilling skills which are required in different segments of legal practice or engaging attention. But for instance, in Australia, they have set up newly a national council for graduate attributes. So every university will meet annually and find out what are those graduate attributes which you can say a graduate graduating out of a law school fulfills. And these graduate attributes are periodically to be revised by a national council of deans of universities. I think it's a very important step to be taken in our country. I said the defunct National Law Teachers Association will have to be rejuvenated. And so some of these concerns I think will get more and more clear as we walk into the next session. And I'm extremely thankful to both the panelists and your attention. Please do.
I just wanted to add one point, and I think UPES faculty, please do make note of this, because this is one of these. I broadly spoke about communication skills, but I just wanted to focus on writing skills, and I'll just take a minute. The thing that actually we lawyers probably sometimes don't realize is that almost maybe 70-80% of our time is spent in articulation, either writing or verbal. And I'm on writing skills here. This is one very serious area of deficiency. And there are misconceptions. In fact, a lot of times we have to tell people to unlearn what they may have learned. And I'll give you just one example. Use of Latin. I actually, we as a firm, and particularly for me as a person, I try and promote the concept of plain English. For example, I have tremendous problems when in our agreements we write, you shall do this, you shall do this, the lessor shall do this, and I always say, actually, how many times do we use shall in our day-to-day language? Instead of saying, shall we have lunch? Otherwise you will say, I will go, I will do this, so why not use will? So will, shall, for example, it's a drafting convention, but Latin, I was just going to tell you, so I was actually trying to speak to a group of young lawyers in the office, and we're talking about plain English, and that's quite simple, not many long sentences, don't use long words, because if your reader is going to pick up the dictionary to figure out what you are saying, then you failed in your mission to communicate. So I said, don't use Latin words. And this youngster tells me, he says, but what I was told that we must use Latin words, otherwise it just doesn't look legal enough. And I'm saying, sort of, for a corporate lawyer and dealing with corporate clients, most of the time your audience is not lawyers, nor they are judges. And in fact, judges have repeatedly said that, legalese is something that should be avoided, so don't use Latin. And the person said, well, it doesn't sound strong enough, it doesn't sound legalistic enough. So I would urge that just from moving away from conveyancing. I remember when I did law, the only thing, anything about writing was conveyancing, and it meant nothing because you just mugged up a lease deed and the exam said write a lease deed and you wrote a lease deed. But drafting skills, language skills, how can we use simple English in our communication and our work, even drafting as lawyers? I would urge that UPES should take lead in this, in terms of saying how do we start promoting use of plain English for lawyers and not legalese. Thank you.
Oh yes.
Mic. Will.
I'm extremely grateful to Mr. Jyoti Sagar for his exposition about the skill that we need to impart to the students. For every kind of education, I think three aspects are very important. It's just a reaction, not a question, actually. That is knowledge, then skill, and then attitude. So, this attitude has been disturbing me for quite some time, ever since I'm into some kind of academics and into training of lawyers, judges, and other people. Attitude, I think, is very important component for any kind of education, and particularly for lawyers. And this attitude should include also the sensitivities. Sensitivity, for example, towards gender issues, towards issues concerning the weaker sections of the society, towards children, and towards people we do not fully identify with. I personally felt various times, acting as a judge, that the lawyers sometimes lacked the sensitivity while dealing with a case, although not relevant perhaps the topic here. For example, dealing with a case of rape. You may represent the accused, but you should be fully sensitive to the victim. So I think our legal education, if we are talking about skills, we should also talk about the attitude and the sensitivities. Just to react to, I'm very thankful to Dr. Jyoti Sagar for coming out with soft skills as necessary elements of skilling.
Thank you very much. I think it's a very relevant comment, and often you hear that the best thing that you bring to your workplace is your attitude, because you can learn a lot, but attitude is important. I entirely agree with you, and that's again in terms of what we spoke earlier about the role of a lawyer as a healer, how should a lawyer conduct himself or herself. So I think clearly the issues of attitude are very, very important, and what you are saying is of great value. Thank you so much.
Any other question?
I was really inspired by Mr. Jyoti Sagar's rich experience, and therefore, it's a good thing to ask somebody who's experienced. Then you get a proper feedback on a time. Now, one of the components that we are facing today in India is how do we adjust to the times? A time when there is complete disorder to a time there is complete order, and somewhere in between also. The Supreme Court, in many of the domain areas, for example, in sandmining, for example, Supreme Court has issued Deepak versus State of Punjab. Sandmining activity is going on in the riverbeds, spoiling the ecology. And they're given 9 recommendations. Now, in a previous thing in power, we had grid management, which is completely technical. Now, in situations like this, the parliament ought to have done something about it. The administrative people had to have done something, but the Supreme Court is taking recommendations on behalf of the people. So I believe that somewhere down the line, in America we had a Sherman talking antitrust laws 150 years back. We had many people, many lawyers like Lincoln who actually did the Second Amendment, freedom. But somewhere in our education, maybe, that we are not adequately addressing public interest litigations, how to conduct it. Because if the courts are taking the duties of the legislative, because the legislative is engaged in other superfluous activities, there is no harm in it. There is no hard and fast rule which says that the court should not be forthcoming when there's something actual or factual to be done. So in that event, is it not possible that we can have a dimension of, say, law and public policy? Many of our politicians in the world have come from law, leaders. So is it not time for us to see a proactive committee by virtue of public interest litigations? We don't have any sessions which says, how do we go about this? Just to address Justice's concern about ethics. Fine, we understand that, but how to execute it from a court platform? So I do hope we have these two things. I don't know what your reaction would be on law and public policy and the technique of public interest litigation or friends of the court.
Let me quickly clarify one, that I don't claim to be a public policy expert, and I'm certainly not a constitutional law expert. I think my friend Mr. Venkataramani would be able to answer some of that better. But purely from a perspective, of a layperson, my response is actually that in a society and in a country in which you have proper governance, there should be no need for PILs. To be honest, again, I think what's happening is, you alluded to it, but I will say it more bluntly and clearly, that you have the legislature, the executive and the judiciary. Unfortunately, we come to a stage in our country where, I dare say, because it's very controversial, it's a statement to make, but I would still say it, it seems that none of the three are doing their own job. They're doing somebody else's job. Look at judiciary. We live in a glass house and we are throwing stones at everyone. Look at our pendency. Look at our transparency. And then we are out there telling everybody what they should do. So 20 years ago, the Supreme Court had to tell the Delhi government, do C and G. Why didn't that proposal come from the Chief Secretary? Or why didn't that proposal come from the Chief Minister? Why would the Supreme Court need to do it? Right? So legislature is doing the executive's role, executive is doing something else, courts are trying to run the country. You cannot run a vibrant country through that process. Courts have binary decisions, yes and no. Courts cannot handle complex issues like the diesel cab issue that you have. So now you put entire BPO industry at risk, and I'm not saying you should run diesel cabs. So judicial orders, judicial interventions cannot be crafted all the time to meet the day-to-day needs of things which can only an executive can do. So I honestly don't know much about it, except to say the PILs shouldn't be there at all. If everybody did their job, you won't need PILs.
Professor Sampath, I'll just conclude. We are running into the next session, but since you raised this question, having authored a book on public interest litigation, which is published by the Supreme Court, the restatement of law in our country, the only thing I would say, we are in the context of the role of legal education institutions in being able to offer a package of knowledge and skills and attainments. What kind of basket of knowledge will a student carry outside? And if you have to forecast all possible subjects of study which may emerge in the course of collision between institutions of governance, I think you are going to be at wit's end. But probably what has happened over a period of time is a remarkable commentary on the performance of institutions of governance in our country. That's the one important thing. From that, do we learn a lesson as to what kind of inputs in the basket of knowledge with the legal education institution should go into? Certainly, I agree with you on that score, but namely, would fundamental principles of professional ethics and morality would persuade a student of knowledge of constitutional law and governance? Because today, constitutional law is all about governance. Okay? So we look at it like that. A student of such knowledge on what principles of professional ethics and morality and understanding of public policy